You're welcome to my channel. We are still continuing with business law. So in this video we are going to be talking about the structure of the courts and administration of justice in the Ugandan legal system. So this subtopic in business law has very many other subtopics under it, but the first thing that we are going to look at are the key terms in this matter. So the first term that we have is jurisdiction. Jurisdiction refers to the scope of powers vested in a particular court relating to what kind of cases it can handle. So simply, jurisdiction is like the limit of the court's power or the limit of their authority, how much they can handle, what they can handle. So it's the scope of the powers vested in a particular court relating to what kind of cases it can handle, and this is determined. So to determine the power of a particular court, they base on these three things: the value of the subject matter, like how much is involved in that case, the location where it is located, and then the nature of a particular offense. That is the term jurisdiction. Then we have the next term, which is pecuniary jurisdiction. So this means the monetary value of a subject matter which a court is allowed to handle. So it's not like every court can handle any case. They base on some things. So for pecuniary jurisdiction, it means the monetary value of a subject matter which a case is allowed to handle. For example, in Uganda, any case whose value goes below 500k, that case is supposed to be heard by the magistrate grade 2 court. Then whereby the value is below 20 million, it is supposed to be filed and heard in the magistrate grade 1. Whereby it is below 50m, it is supposed to be heard by the chief magistrate court. And whereby it is above 50m, it goes to high court. So pecuniary jurisdiction, it means the monetary value of a subject matter which a case is allowed to handle. So we base on those examples that I've given. Then the geographical or territorial jurisdiction, it's another term that we have. Geographical, it is something that is related to location. So geographical jurisdiction refers to the power of the magistrate court to handle cases. The power of the magistrate court to handle cases, and these cases can be civil or criminal, that arise within the local area where the court is situated. The power of the magistrate court to handle cases that arise within the area where the court is located. For example, if Sharon trespasses the land that is located in Nakawa division, and that land belongs to someone who is in Nakawa, the court that is supposed to handle that matter is the Chief Magistrate's Court of Nakawa. They can't take it to another location since it happened in Nakawa. So that is the geographical or territorial jurisdiction. Then the Court of First Instance. The Court of First Instance, it refers to a court where an action is originally commenced and heard, like where they first file the case and hear it, where the first hearing is. That's what we call the Court of First Instance. As we said, any amount, any case whose value is below 500k is supposed to be heard in the magistrate grade 2 court. So that becomes its court of first instance, where the case is first filed and then heard. That's what we call the court of first instance. Then the serious criminal offenses are heard in the higher court, whose value is above 50m. So the High Court becomes their court of first instance. Then we have other terms. Other terms that we have is appellate court. Appellate court comes from the word appeal. Appealing, it's like requesting. So appellate court is the higher court in hierarchy to which an aggrieved party may seek remedy by way of challenging the decision made against him or her by a lower court. So appellate court is any court that is above the lower court, whereby someone, if someone is not satisfied, they can go to the higher court and they challenge the decision that was made in the lower court. For example, if someone is not satisfied by the decision that was made by the magistrate grade 2 court, they can appeal higher court. If still they're not satisfied, they can go to the Court of Appeal, then the Supreme Court, like that. So the higher court in hierarchy, in which an aggrieved party may seek remedy by way of challenging the decision made against him or her by a lower court. Then another term that we have is the appellate jurisdiction. So this one refers to the power of a higher court in hierarchy to either affirm or reverse a decision of a court below in a case brought to it by a party dissatisfied with a decision from the latter court. So appellate jurisdiction is the power of that higher court. They have the power to either affirm or reverse the decision of that court. So that is the appellate jurisdiction, the power of a higher court in hierarchy to either affirm or reverse the decision of a court below in a case brought to it by a party dissatisfied. Then another term that we have is issues. So issues refers to the points of contention. It refers to specific questions or disagreements that need to be resolved by the court, and they are points of contention between two parties involved. For example, the court may need to determine if the contract still existed, if someone broke the terms of the contract, or if the person who was wronged is entitled to compensation. So it's like questions or disputes that need to be resolved by the court. So for example, the court needs to determine whether there was a contract between the plaintiff and the defendant, whether the defendant breached the contract entered into with the plaintiff, or whether the plaintiff is entitled to remedies prayed for, or they are entitled to compensation. That's what we call issues. Then another term we have is laws applicable. Laws applicable refers to the relevant act of Parliament, the delegated legislation, the case, common law, equity, custom, or authoritative textbooks to be relied upon when they're resolving the dispute. Like what they are going to rely on, what they're going to base on, what they're going to refer to when they are resolving a particular case. That's what we call the law applicable, and it can be an act of Parliament, delegated legislation, a case, common law, equity, custom, or a textbook. Yeah. Then another term that we have is the decision of the court. So this one refers to the conclusion that court draws from summing up the facts, evidence, and the law. So after the court looking at the facts of the events that are being talked about, the evidence, and then the laws applicable, the court comes up with the decision, and that's what we call the decision of the court. Then another term we have is ratio decision. This refers to the reasoning of the court. the justification for reaching a particular conclusion. So the court has to have a justification, a reason, like as to why they have come to a particular conclusion or as to why they have made a particular decision. That's what we call ratio decidendi. Then the last term that we have is the suit. This means a claim that has been duly filed in court, a case that has been filed in court, and the process of filing is called suing. So a suit is essentially a legal action whereby one party, who is the plaintiff, brings a case against another party, who is the defendant, in court to resolve a dispute.